Welcome everyone, Orlando Torresia from thinkistorresia.com. Well, we are talking about a residential rental contract. Note, a residential one, which is covered by the whole of Title II of the Urban Leases Act. It is neither a seasonal residence, nor a tourist property, nor any other type of premises. So, this is a residence, a habitual residence. Then, Article 11 of the Urban Leases Act tells us that the tenant may withdraw from the lease agreement once at least 6 months have passed, provided that they notify the landlord with a minimum of 30 days notice. So, from the 6th month onwards, even if they signed for 5 years, which is actually the standard term for a habitual residence rental agreement, well, even if they signed for 1 year, 2 years, 3 years, 4, 5, or 1 and then extended it, they have the right from the 6th month onwards to withdraw from the rental contract, as long as they notify the landlord with a communication at least 30 days in advance. Well, in the event of breach of the contract because the tenant leaves after the 6th month, well, the parties can agree, and they are allowed to do so, but of course, it must be included in the contract that the maximum compensation will be 1 month for each year remaining in the contract. But that's from the 6th month onwards. From the 6th month, what happens before 6 months have passed since the start of the contract? Well, in the case of withdrawal from the contract before 6 months, Article 11 of the Urban Leases Act says nothing. So, where do we go? We turn to the agreement between the parties, to the Civil Code. So, we can include that in the case of early termination of the contract by the tenant, before the 6-month term has been fulfilled. This will give rise to compensation equivalent to the outstanding months to complete 6 full months of the contract. In other words, if they leave before the 6 months, they will have to pay the remaining months until reaching the 6-month mark. This is completely legal because it's based on what the parties have agreed, and it does not breach Title II of the Urban Leases Act on residences. For habitual residents, to be clear. So, very important, because this will help us detect people who only want to stay 1 or 2 months in a rental contract for a residence, but who claim they want a minimum of 1 year. So of course, if you tell them they'll have to pay 6 months, even if they stay 2, they'll probably refuse to sign that contract. Though this clause is very important to uncover whether the rental period that a potential tenant for a habitual residence actually wants is truly 6 months or more, or in fact less than 6 months, and they are trying to deceive you. So get in touch with us, because of course, all these clauses and contracts must be reviewed and drafted by someone with expertise. And specifically, we recommend any officially registered estate agent. So, if you have any doubts, we are available by WhatsApp on 6930-23926. You can make a video call with us at a very small cost to begin your rental contract review or advice. So until the next video, God willing, Orlando Torresia, thinkistorresia.com.